Hello and welcome to a podcast episode of Textwired by Aman. This is a podcast where I discuss topics in textile and fashion to educate consumers like you. So, our topic for today is going to be very interesting for business owners because we are going to talk about credit. And our whole question for today is why giving credit in a business feels so insecure. And to help discuss this whole podcast, we have Utsav, who's a school friend of mine. He deals in technology, commercial, and constitutional law and policy, and he also has a podcast and writes regarding to such topics. So I think he was the perfect person to bring on this podcast to discuss this topic specifically. So Utsav, welcome to the show.
Hi, Aman. It's great to see you.
It was great to see you too. Finally, we have a
Yeah,
podcast.
yeah.
Okay. So to begin our conversation today, I think it's very important it's important to build a scenario of a business model. So based on that, we can build our discussion, and it'll be easier for listeners to catch on also. So let's just start with me. Let's just say I am a small trader in this textile industry. I help source fabric for businesses who make garments. It can either be for branded and non-branded garment manufacturers. We can come to that later. So, as an owner who is just starting out and has limited funds, I will need to rely heavily on credit. Based on today's topic, what I want to discuss with Utsav is after I give me as a small trader, after I give a credit to my client, why does it feel insecure that I always have the second thought that what if my client run away and never pays me back? What do you think, Utsav?
I agree with you that there's a lot of things to take into consideration when we're talking about credit, especially in the industry in the for when you talk in the context of small business owners or middle-sized
Right.
businesses, MSMEs or the
Right, right,
like.
right, right. So before we get into this whole problem identification and possible solutions, which I'm sure you have a lot of it for our viewers today. So I just want to cover some statistics of this textile and garment industry in India.
Well, following up on your last episode of Texwired, or the last one that I saw, which was about how the garment industry overall, and especially luxury
Right,
coats and
right.
different kinds of clothing, have been affected by the pandemic because social events have reduced. People aren't
Yeah,
going to the office regularly, they're working from home,
right.
they're falling sick more often. So, all of those things have impacted demand in this industry, as a result
Right.
of which businesses are more reliant on credit. And if you even look at the RBI is coming out with schemes for credit, and they are trying to contemplate the best way to go about it. And even in foreign countries, for example, the
Right.
UK has also especially come out with schemes for small businesses for credit and for helping them pay their salaries to employees, for purchasing the raw material, for
Yeah, yeah, yeah.
sustaining themselves in this time and getting licenses, compliances. So even like, for example, as per a recent report, the total amount of credit that was availed by the clothing sector in December 2020 stood at 1.62 lakh crore.
Wow.
And this was due to suspension of manufacturing activities in the aftermath of COVID lockdown in March 2020. So the industry actually observed a quarterly decline in non-performing assets over the last 2 years, from 29.59% in September 2018 all the way to 15.98% in September 2020.
Wow, that's a drop of like 15%. And of course, when activities shut down and the assets that so the manufacturing plants are considered assets in the balance sheet, so that obviously increase a lot of the non-performing assets, I'm sure. So geographically, what I've also when I was doing this research, I also found out that Maharashtra has the largest share of credit portfolio at 25% of the credit book to the sector. So the report emphasized to like the top 13 regions in India, which are rich in textiles manufacturing, accounted for about 80% of the credit portfolio as of December 2020. So nearly the nearly all states have district manufacturing textiles and apparel, and they also have several credit active units. But uh, to see the ones that have the highest proportion is going to be Maharashtra and Surat, who has about nearly 10,000 crore credit portfolio as of December 2020, which is huge, which is a lot of credit. And I'm sure the COVID-19 pandemic just made it a lot worse to pay back such loans.
Definitely, COVID-19 really beat the ball out the park. Things have just moved into another, proportion, and
Right,
there's a heavy reliance on credit. There's delayed orders. Even there's logistical problems, such as if you place orders online these days, so you won't get your deliveries on time. There's so much that has happened in the world of both physical and e-commerce, which
right,
has changed. Now all of this, when we look at all of these problems, it all comes down to contracts, right?
right.
So, two business parties before entering into any business should secure their business by contract, is what all lawyers say. It is a good way to avoid disputes, to avoid
Right,
disagreements.
right, right,
Yeah.
right,
But what do you think? I've observed, Aman, that many small and mid-sized businesses, especially, are reluctant to enter into formal contracts. So, I wonder, what is the factor which is creating fear in their minds? Why don't you tell us about it?
yeah. I'm glad you asked, because as a small business owner, it will be it'll be very difficult to actually arrange credit in the first place. So to get that credit, we don't want to lose it, because that will ruin the credit score. So I think the biggest factor that causes this fear for a lot of small traders is because of the competitiveness of the market. Like you mentioned, it's very important to have a contract, and by default, every buyer and seller should have a contract. But that is not the case in textile industry, where the market is so competitive. So because of this competitiveness, a client can have so many suppliers, and also all these suppliers are ready to comply with the terms of the client. If I'm dealing with a client and they would like a credit of 3 months, and 3 months is something that I cannot afford, I will just have to let the client go, because there are so many other people who are working with different capital structure. They will be able to offer like much better credit terms for the client. So I just end up losing a client just because I cannot give such a long term for credit. So there is this thing that if not you, there'll probably be somebody else. So which means if I can't offer such long term credit to my client, it is very easy for them to find somebody else who will, probably next door. That's how competitive it is. Like that is one rule. And also there is a universal rule that the whole textile trading business just happens on credit. So in textile industry in India, usually the credit terms is between 2 months to 3 months. But because of the COVID situation and some businesses not performing so well, these payment terms have been extended to 6 to 8 months. And I think that is crazy amount of time for any business, because if I'm selling to a client and the client says I'll pay you back in 8 months, wow, that's that's not acceptable. And imagine you talking about contract, because contracts can be binding, and it's signed. So it does not allow flexibility for anybody. Like and in terms of client, if even if you ask me as a owner, if a supplier would ask me to sign on a contract that I would pay my supplier back in 2 months or 3 months, I would also be like, okay, that's a little too much for me, because I would also need some time to market my product. So 2 months is just gonna uh, might seem a lot, but it is doable. But what if my clients default, or they don't, or they ask for an extension? That will fall on me, and I will also want. And if I have a contract with my supplier, I would not want that. So it's a thing that everybody will not want a contract, because then it does not create flexibility as a personally, as a business owner, or for anybody. Like they would love the idea for credit, but as a whole, in the economic view, it's not good. because it kind of like slows down the rotation and it causes a lot more problem. It's very difficult to have that conversation.
I get what you're saying, which which brings me to think about it, that whether this is the right way of doing business without a properly codified contract.
Hmm.
So I have seen some people work with their brands, and their way of doing business is very structured. Now, why is it that small, like one person companies or smaller companies and traders, that they are not doing it in the same structured, regulated manner?
Hmm. Yeah, that's a very good comparison, like of a small trader and an international brand. Like, okay, if you look at the value chain, obviously it's the same. You have a supplier who does the manufacturing, and then there are traders who help source the fabrics for the clients, and the clients are usually brands. They have a very strict rule and quality of fabric that they require. So I think it comes down to the scale of the work, because such brands, they usually have a large amount of capital, financial capital, to help support their brand. So these brands, by default, they have a large order because they are spending a lot on marketing. So they have a huge consumer base who are ready to buy their product, and having a huge consumer base means the business will require to order more fabric for their garments, and more fabric means large demands. If I get an order from a brand, I think I'll be good for the next 3 months.
Right, right. That makes sense to me.
Yeah. So, also, as a lawyer, what do you think can be the focal point that should be covered in a basic agreement? Suppose if I'm a small business owner, like I mentioned earlier, for the sake of this podcast. So, as a small business, when I am approaching my client, what do you think should be covered in a contract where it doesn't seem so daunting, and it seems like there is so many conditions uh, that has to be followed just for a contract.
Yeah, yeah. So since we're talking about credit sales here, and a lot of the, especially work in the garment industry, revolving around
Right.
credit sales, I'll actually discuss some of the clauses, the most important clauses that I drafted in one scenario where I was a wholesaler and retailer in the garment industry, and I was acting for the wholesaler. So in
Right.
this case, I would say that firstly, the two main statutes that I looked at were the Indian Contract Act
Okay.
1872 and the Sale of Goods Act 1930. So
Right.
these are one of them. The first one, Contract Act, deals with contracts and sale of goods, specifically regarding sale of commodities. Now, over here, if you look at it, what is which is different in today's credit sales contracts is the
Yeah.
force majeure clause. Now, let me
Mhm.
tell you what is the meaning of the word force majeure. Force majeure means something which is an unforeseen event, such as an act of God, such as, say, a natural disaster, a flood, or a fire,
Okay.
something which can't be conceived of beforehand. So the force majeure clause should be very specific, because it must clearly state that COVID-19 is not included in it. Say, because
Okay.
normally the word force majeure will include pandemics, but these days we can create traders entering into contracts. So I especially carved an exception in the force majeure clause of this contract, that COVID
Okay.
19 will not be covered, and they will not be able to evade their obligations under this contract just because of COVID 19 or
COVID-19.
related restrictions. Now, if they want to specifically cover, say, delay in delivery or things like that, then they can include that in their clauses, that a delay in delivery should be allowed because of, say, COVID related restrictions. But altogether,
Hmm.
they should not be allowed to evade their obligations.
Okay. Okay. So
Then,
this clause
then,
does not.
yeah.
This clause includes all the unforeseeable events, but COVID is
uh,
usually not a pandemic is not usually part under this clause.
Actually, normally it is, but these days they are specifically carving exceptions in their contracts that COVID 19 is not covered under force majeure.
Okay,
Because
okay.
if they include that, if they don't do that, then say any party can say that, oh, COVID-19 is also an unforeseen event,
Oh
and
yeah.
they should be allowed to not fulfill their obligations because of COVID. But COVID
Mm.
19 is no longer actually an unforeseen event, right? Because now we know
Yeah,
that it's
not
there.
anymore. Yes, yes,
So
yes.
so that's why we should specifically mention that in your contract. This is not covered under force majeure to avoid conflict in the event of a dispute.
Right, right, right. It's
And
ongoing. Yeah.
yeah, because it's something which has very much been going on for more than a year now, so it's no longer unforeseen or unknown. And then one
Okay.
of the
Right.
important clauses is the price clause, right? The
Yes,
price
yes.
clause should specifically say that it is not inclusive, or that it is that additional amounts such as the taxes and miscellaneous expenses should also be paid by the buyer,
Mm.
and the complete amount mentioned in the invoice has to be paid by the buyer. So that is
Right.
something which is very relevant here.
Right. I think yeah, price is
Now,
the huge
now one of
factor.
the
Yeah.
most important aspect, yeah, yeah, definitely. So price is really relevant here, and then it's also the security of collateral. So any kind of credit sale, or in fact, even in a banking agreement, there is security or collateral. Any loan agreement,
Right.
there's security or collateral, right?
Yeah.
Similarly, in a contract for simple credit sale of goods, the security given is mostly in the form of a post-dated check. So
Right.
this means that if the buyer does not pay for the goods, so the post-dated check can be presented by the seller to clear
To
away
clear
the
the
amount, right?
payments. Right, right, right. And does
Right.
having an advance payment, does that also
Hmm.
come under a collateral clause, like an advance payment, or that's not?
Actually, an advance payment is a different thing, right? So when you're having credit sale agreement, we're going, either we mention that okay, so much advance payment has been made and so much is remaining, but the agreement is
Okay.
mainly with respect to the amount which has not yet been paid.
Okay. Okay.
So
Right.
that
Okay.
that's as far as advance payment goes. You can
Yeah.
you can mention that so much amount should be paid in advance, so much will be after delivery.
Mm.
That's a different thing.
Okay. That's okay. Fair.
Yeah, but in this case, in this contract, it was all for like completely, like for example, the seller was giving them the retailers the product, the
Right.
seller here being the wholesaler, he was
Yeah.
giving, the purchaser was the retailer, so the purchaser was being given the good all of the goods in credit completely to sell forward, and then they would be paying back the wholesaler after selling those goods, which is I think normally how it goes about in
Right. Right.
the garment industry for
Yeah.
small
Yeah.
and
Yeah.
mid-sized businesses especially.
Yeah. Yeah. Yeah.
Uh,
Post-dated check is yeah. It's usually universally accepted also because it's bank.
yeah, yeah. Yeah. Then you have things such as the delivery clause, right? So if you look at Section 11 of the Sale of Goods Act, it states that time is not of the essence in a contract unless the parties to the terms intend to make it so. The
Right.
delivery of a contract for sale of goods may actually be drafted to prevent the seller from being held liable, right? So in the event there is a delay, we can specifically mention in the contract that the buyer will not be able to evade paying for the goods just because of a delay in the delivery of goods. And this is supported by
Mm.
the fact that it is not one of the essential conditions of a contract for sale of goods, as per the Sale of
Right.
Goods Act.
Yeah. Yeah. I think this is the fair clause because because of small incidents, delivery can be delayed by uh, uh 2 days or 3 days. So yeah, being strict on the exact date can be a little too yeah, a little bit too harsh. I would say
Exactly, and it's
because
it's
that happens.
unviable. It's
Yeah.
unviable for the seller.
Yeah. I
So
because I've been through it. So yeah. Yeah. When you were just reading this, I was just reflecting in my brain like, oh man, this is this is too harsh. But yeah, I'm glad.
and then there's a title clause, right? So a title clause should be carefully drafted to state that the title of goods shall only pass to the buyer once they have paid the full price and
Okay.
cleared all their dues. And this is very, very important because the title is everything, right? So if you don't
Mm.
clearly mention this in your agreement that the title only passes upon payment for the goods, so that can create unnecessary hassles. I mean,
Mm.
then you'll have to look at all the legal provisions. So to prevent all that, this title clause should be clearly drafted.
Okay. Yeah.
Yeah. Another thing that comes into the picture is representations and warranties clause, right? So warranty clause is very common whenever you buy something for the market, like a pair of earphones. There's a warranty clause, but
Yeah.
that's because you buy it as a consumer. Now, in this case, this was a contract between a wholesaler and a retailer, which is what most of the credit contracts are.
Oh, interesting.
So that's why we specifically mentioned the presentations and warranties clause that the provisions of the Consumer Protection Act will not apply, because that is only available to a consumer transaction, and this is actually a commercial transaction for resale. So that's something
Oh,
relevant, I would say,
oh, okay.
which
So
you have to
Consumer
mention here.
Protection Act does not work as a warranty for a client.
Actually, it doesn't apply to resale contracts. So even if you look at real estate transactions, right? So if you go
Right.
to consumer court, so the first defense that the sellers take there is that this person is an investor and not actually a real buyer. And then
Okay.
you'll often say that if you're acting for the buyer, we say that no, well, we have more than one residence, but that doesn't mean that this is a mere investment, right?
Okay. Yeah.
So
Fair.
the
Fair.
seller
Fair.
will always try to show that this person can't approach the consumer court because they are only an investor. So the same thing
Oh.
applies for these contracts, that
Okay.
the
Okay.
provisions will only be applicable to consumer transactions
Okay.
and not
Very
commercial
interesting.
ones for
Yeah.
resale.
It's a very important clause.
Yeah. Yeah. Then you have your dispute resolution clause, in which you decide what path to take in the event of a dispute. So you must have heard that arbitration these days is very popular. People
Mm.
like to resolve the disputes quickly through arbitration, where there's an arbitrator appointed at the choice of the parties. And the only issue that sometimes may arise here is that the fees of the arbitrator is greater than that of what you have to pay in the courts. But
Mm.
this depends upon the volume of the transaction. So in this particular contract, since it wasn't for very large transactions, that's why I avoided mentioning the arbitrator. And I asked the party, and they said that okay, there's no need for an arbitration clause. But for bigger
Mm.
contracts where you have like larger amounts involved, larger sale volumes of goods,
Right.
so generally arbitrators are preferred.
Mm. So
It's in
arbitrator
fact a
is a
more
third
popular.
party that comes in and helps solve the dispute, but they will have a separate charge for it.
Yeah, and they have to follow the Arbitration and Conciliation Act.
Mm. Oh, okay. So these third party also have a clause that they have to work under to solve a dispute as a third party.
Yeah, so they are governed by the laws of arbitration and even the general like civil and commercial laws.
Okay,
And
okay,
in the
okay,
sense that the procedure is regulated by, say, the Arbitration Act or the rules of that particular arbitral tribunal. But
okay, okay.
uh,
So this
but other
third
than that,
party,
the law
yeah,
applies.
sorry.
Yeah.
Yeah. So this third party, do they have to be certified or registered under the government or um, I don't know what's it called. Do they have to be registered to be an
They're
arbitrating
at the
party?
choice of the no, it's at the choice of the party. So normally we find that arbitrators will be retired judges, will be practicing lawyers, but they're
Okay,
basically at
okay.
the choice of the parties. Yeah,
Okay, okay, okay. Okay. So it's just
yeah.
not any random third person coming. Okay.
Normally not, because they have to still follow the laws. So it can't be that any person can be. Although there's nothing specifically saying that it has to be, of so and so qualification, but
Mm.
we choose the arbitrator on the basis of the suitable person to resolve the dispute.
Mm, fair, fair. Yeah, I think that just makes it more secure in term like when it comes to disputes because if there are contracts and somebody is inconvenient, dispute is yeah, dispute just happens by default. So if on yeah in the conversation of like dispute, so what are the possible issues relating to breaches of contract or when there is a disagreement? How can somebody protect themselves despite having a contract? Like you have a contract. Suppose I have a client and he's not being able to pay me, but I'm trying to use my contract to remind him that his payments is due or it's going to be a case. So uh, before so if I don't want it to come to that stage, so what are a few remedies that one can protect themselves and not have not be a huge issue despite of the breach?
Well, so the first thing you can do is go for, arbitration or even mediation. If you've mentioned in a clause that the first step will be mediation, then you can go for mediation first. If an arbitration clause, mediation is similar to arbitration, except arbitration involves the arbitral procedure, the Arbitration and Conciliation Act, whereas mediation is just like a meeting between the parties. And if you don't have a mediation or arbitration clause, then you
Right.
can invoke your civil remedies, which is basically going to court. So over there, you
Mm.
can, institute a suit for damages, a suit for specific performance, or a suit for restitution. Now,
Right.
restitution means putting the party back in the position as it was. So, for instance, that means, returning the goods. Whereas specific performance is that, requiring them to perform their obligations. So, like paying the price for the goods. Damages is
Right.
basically the penalty that they have to pay for breaching the contract. So these can be liquidated damages or unliquidated damages. Now, liquidated damages are those which are already fixed under the contract. Say that,
Okay.
1 lakh you have to pay.
Okay.
Or and unliquidated damages are which are to be determined, and
Okay.
in the court, that okay, how much damage should be due. And it's
Mm.
generally easier to go for summary procedures when there are liquidated damages.
Okay. So I think, yeah,
There's
liquid
more
would be like just like a fine on top because of the breach, and illiquid would be
unliquidated, you
that
mean? Yeah.
unliquidated would be decided by the court.
Yeah, unliquidated would be that okay, or it could be like, the parties then say, like, the plaintiff, the person who's suing, says that this much should be paid to me, and then the court decides that okay, is that a suitable amount or not. That's
Mm.
unliquidated. Unliquidated is when it's already fixed in the contract between the parties.
Oh, interesting. Very interesting.
Yeah. Yeah.
What more can do you think?
Well, so a lot of disputes, they involved check bounces, right? So your buyer might
Okay. Oh,
pay
yes.
you by check, and the check might bounce. So then you have a simple
Mm.
remedy under the Negotiable Instruments Act, where a complaint can be filed under Section 138, check bounce. Now, this is a summary procedure, and technically it falls under criminal law, and the
Oh.
person who it is, filed against is an accused, but it's not like hardcore criminal provisions where they'll be sent to jail for
Right.
a very
Yeah.
long time. I mean, there
Yeah.
are provisions for all that also, but not like it's supposed to be a simpler dispute resolution. And in fact, if the party who's accused can, if they accept their liability and if they don't file a reply, then they can
Right.
straight away go to mediation. So that's why
Oh.
it's under a check bouncing procedure, check
Okay.
bounce complaint
Yeah, because
procedure.
a check bouncing, and then you just all of a sudden, you just tell somebody a check bounce is considered, a
Yeah,
criminal
yeah,
law. All of a sudden, nobody wants to do that either. So that's
yeah.
going
I
on.
mean, it is a criminal offense technically,
Yeah, it
but
is. Yeah.
it falls under it's a separate act for it, the Negotiable Instruments Act.
Okay.
Yeah.
Okay. Okay. So we have arbitration, which is a third party.
Hmm.
Another
Hmm.
one is civil remedies, which is liquid or illiquid. Is it illiquid?
Unliquidated
Yeah, liquid and unliquidated uh, measures, which is fees or
damages. Yeah.
yeah, a fees or which will be decided by the court. And the third one is if a check bounces back, then yeah, you can have a summary procedure, which happens
Yeah,
under
yeah. Under the
criminal
Negotiable
law.
Instruments Act. Yeah, yeah.
Okay, okay.
Yeah, and a well-drafted contract can help avoid more complications in the event of a dispute. They can help resolve a dispute faster, make it less
Hmm.
expensive for both the parties. Less gruesome, if I might say.
Right.
Uh, I would say the whole fear of not entering into contracts, having informal agreements, uh, are actually more detrimental to business in the long run, and they create hostility.
Hmm.
They lead to problems. So contracts can help resolve all that. Also, meeting all your compliances. If it's a company which is 10 or more employees, there's so many other compliances which small businesses are often failing to meet, and then they face problems under labor laws. There's the new
Hmm.
labor
Right.
codes. There's sexual harassment at the workplace related compliances for 10 or more employees, maternity benefit laws,
Right. Right.
shops
Right.
and establishment related registration. So shops and establishments is a very basic registration, which a
Hmm.
lot of times I have found in cases that small businesses haven't actually done that. And then when there are labor disputes with their employees, all these things come into the picture, and the first thing the labor officers ask is that okay, are you registered in the Shops Act? And I have to tell
Okay.
them that okay, we'll just get registered in a day, and it's a very simple procedure. Shops and establishments, you just have to go online and register yourself under the
Hmm.
state that you are in,
Hmm.
and
Yeah. Yeah.
all that can become simpler if these
Right.
compliances are met from the outset. I feel, and
Right, right, right.
contracts are respected. Like
Mm,
some regulations should be there, some, and that can only benefit your business. So that's
mm,
what I always encourage people to do. Yeah, to
right.
avoid
Yeah.
litigation and court
Yeah.
disputes. Yeah.
Yeah, I think yeah, I think that yeah, that's very important, and I think you already said everything that's needed for anyone who should encourage themselves to set up a contract and register themselves under this all these act, and also check out few of the laws regarding credit sales. So I think it's a very important discussion that we had today. Thank you so much once again for coming to the show, Utsav. I think we already have a next episode coming. So thank you
Yeah,
for coming on the show.
thank you so much for calling me over, Aman, on the show. And yeah, looking forward to more episodes with you. Yeah.